Good morning, Jeff Asher.
Yes, Mr. Asher, this is Jeff Langley. You had called our office last week, and I was just returning your call.
Hi, Mr. Langley. No, I hadn't called your office. Your office had actually called me. It was your investigator, Mr. Green.
Okay, maybe it was you had called the sheriff's office, and I think they had spoke to Mike Green. He spoke to you anyway. He gave me a message and asked me to give you a call back about your question.
Well, I don't really have any questions. You're familiar with the case, I'm sure. We have personally spoken in the past.
Yeah. Yeah,
and
about the situation regarding the search at your home, and I know you filed a civil suit, and I heard you did prevail, get some damages on your civil suit.
Yes. Well, you'll recall that I came to you, and we spoke personally about Benji Nix, and the fact that in December of 2008 it was uncovered that he had robbed my house while he was there. And GBI did an investigation, and they brought it before you, and you refused to take charges on Benji Nix.
Okay. Well, not so much I refused, in that the GBI did not arrest him. No one arrested him. I refused to try to go indicted, and that basically the GBI didn't feel like they had enough to go get an arrest warrant. I didn't feel like I had enough to get an indictment. And that's kind of where we were at.
You told me that Benji Nix, and I have this on video, if you'll recall, I videoed our entire meeting. You told me that the reason that you weren't going after Benji Nix was because Benji Nix just needed more training. Furthermore, you agreed with me that he hadn't.
Well, that went to some of the ways in which they acted in connection with that search. That didn't go to any theft. You don't have to train someone not to steal something.
Okay. Well,
no one's saying that. Okay.
Well, why then did you not, and why are you still refusing to take charges on him for having stolen from my house when we have evidence that he did this act?
Well, there's some evidence to suggest that. There's not enough evidence to prove it beyond a reasonable doubt, was my conclusion. Apparently that was the conclusion of the GBI also, or they could just go take warrants for it.
Actually, when I spoke to the GBI, they said that they were handing it off so that it could be properly charged by you. It had nothing to do
if there's some new information or something else you'd like me to look at, I'd be glad to, but in terms of just arguing with you about it, that doesn't get us anywhere. But, I have no axe to grind. I'm not a friend of Benji Nix. I've prosecuted other law enforcement officers before. I'm prosecuting several right now for a theft case. Okay, so there's no axe to grind here. I have no, dog in the fight other than that I just make decisions based upon the type of evidence I have available. Okay,
well, the type of evidence that you have available in this case, taking an absolutely narrow view, ignoring the greater majority of things that he stole, is this. There was a sight, a Trigicon sight, and a mount on a weapon that Benji Nix photographed, that Benji Nix was responsible for. He photographed it several times. This was pointed out to you before. Then, when the bag was opened 3 years later, thereabouts, in court by Thomas White, your ADA, the sight was missing. And the sight was never returned, and it was not ever in the bag, because Tom White was the first person to open it since Benji Nix had sealed it 3 years prior. Now, the simple question is, if Benji Nix photographed it, and Benji Nix was responsible for it, and when it was reopened, the bag was opened, where'd the sight go?
I agree. There's a question there. Does that prove Benji Nix stole it?
Well, since he's the only person...
There could be some carelessness. It could be lost. It could mean some other officer stole it. There could be a myriad of other explanations, and that's what I wasn't able to answer, those other possible explanations. And in a criminal case, it's not like a civil case, we've got to disprove those other explanations beyond a reasonable doubt. That's what I didn't feel like we had.
Okay, so you're going to make excuses for Nix.
I don't make excuses for Nix. I don't have any personal relationship with him. I could care less.
Okay.
I'm like I said, I'm prosecuting another officer for another theft case right now.
Okay. Well, here's one that'll be an easy one for you. Mark McClure got on the stand and under oath stated that he tampered with my firearm to make it an illegal weapon. I believe manufacture of a dangerous weapon constitutes a crime in this state.
Okay, now that I don't know anything about. Tell me where that's coming from.
I had an MP
from the transcript from your trial?
Yeah,
or?
This is from the Jackson-Deno hearing in December of 2008. Mark McClure got up on the stand, said that when he found, do you know what an HK MP5 is?
I do not. I'm talking about a firearm.
Yeah, you've seen them before. It's the military full auto version, and military and law enforcement full auto version was very popular for a long time. They've been more or less phased out, but it's a very compact, small weapon that fires a pistol round. And under the law, you have to have a 16-inch barrel on a rifle, an 18-inch barrel on a shotgun. And if you don't, that's called a short-barreled rifle or short-barreled shotgun, or what Georgia calls a dangerous weapon. Okay? No, not an assault rifle. An assault rifle is
an assault-off shotgun.
Yeah,
commonly referred to.
In order for this weapon to be civilian legal, it had a barrel attachment that came from the factory. In this case, it had been silver soldered on. McClure tampered with the weapon to make it a short-barreled rifle so he could charge me with having a short-barreled rifle, and he states on the stand it was legal appearing when I found it. But I thought I could take it off or something to that effect.
Well, he wanted to see if it was just a removable attachment or whether it was permanently attached. Is that what you're saying?
He busted loose the silver solder in order to remove it.
Okay.
The weapon was legal. It was legally configured. It was perfectly legal when he found it. But he wanted to make one so he could have something to charge me with in addition to everything else he wanted to invent.
Did he charge you with that?
Oh, yes, sir.
Okay. Well, I assume
in fact, he tried to get the ATF in on it, and when the ATF found out what he had done, they walked away. They didn't want anything to do with it.
Yeah. But he openly said he removed that attachment.
Yeah.
He didn't try to hide that he'd done that, correct?
He stated it on the stand, under oath.
Well, that's where it goes to his intent. Was he trying to explore whether or not this a weapon that was set up to be easily detached and then made into an illegal weapon?
So you're going to make excuses for McClure now. So now you're making excuses for McClure.
Well, I'm saying what I think his explanation would be if I charged him with that.
If I explore my ability to remove the extension from a weapon, then I've just broken the law. Get it?
No. Does the ATF then, or wouldn't that be a federal charge? Do they want to charge you? The ATF charge you?
Did the ATF charge me?
No, him. This would be a federal charge, right?
No, they didn't.
Okay. Well,
and neither did they charge me.
Right. I don't think either of you should have been charged.
And why should he have been charged, or why should I have been charged exactly?
Well, from what I see, I don't think you should have been charged. I don't think anyone should have been charged. Okay?
I certainly was charged with it by your district attorney's office.
Well, at that point, we followed forth on the warrants that had been taken by the sheriff's department.
Now, why should he have not been charged? Why shouldn't he be charged for manufacturing a short-barreled rifle?
Well, I don't think he was trying to investigate the nature of your weapon. I don't think he was trying to frame you or create a weapon for his own use or possession.
Right. And why don't you think he was trying to frame me?
Well, because he openly said, I took this part off. He didn't take the part and go hide it or throw it away. He said, here's the part I took off, from what you're telling me. I mean, I don't know the detail of that portion of the case, but from what you're telling me, it doesn't sound like there was any attempt to hide that or to present false evidence.
Yeah. He failed to mention that it was properly attached and that he busted it loose. He left out that little key part, and it doesn't even matter. No, he said he removed it. He didn't say how. And I'm going to tell you right now.
Did someone ask him how?
No. Why don't you do that? You're going to make excuses for him just like you did last time. And Mr. Langley, the last time we spoke, you threatened me by offering to recharge me with the same things that I had just had thrown out in that Jackson-Deno hearing. I didn't appreciate that much. Now you're making excuses for these crooked cops again. I don't appreciate that much.
Well, I don't make excuses for crooked cops.
That's exactly what you've been doing.
Cases that I feel like I have enough evidence to be successful in.
Right. So you're willing to threaten me me with charges you knew you couldn't bring.
I'm not
with Sir, I have it on video.
Well, that's fine, sir. I don't recall the conversation, but
I certainly
whatever,
do.
You know, the video would speak for itself.
So you're going to make excuses for these crooked cops. Okay. Thank you, Mr. Langley.
All right. You have a good day. Bye-bye.